Day 2 and 3 of the appeal court hearing heard submissions from Nick Cruz's lawyer, who defended Mr Justice Yeats' ruling earlier on this year. Julian Santos of 5 RB Chambers said the Supreme Court showed the correct understanding and application of the legal principles involved, which were then applied to the judgment, and saw all the defendants' applications thrown out. Puisne Judge Liam Yeats ruled that the allegations made by Mr Cruz, if true, would support a finding of malice. Over 2 days, Mr Santos highlighted what he called the very serious allegations of wrongdoing made by the appellants in their October 2016 press release and also in a subsequent GBC interview. They claim to have been significantly and consistently misled about Enterprise's true financial position. Mr Santos argued that far from being shocked at the state of the company's finances, the defendants had in fact been intimately involved in the process leading up to the Enterprise insurance liquidation. He drew a distinction between a bland press release announcing a major investigation and what he called the seriously defamatory statement issued by the FSC, Samantha, Barrass and Peter Taylor the day after the liquidators' report. Mr Santos said they were not entitled to destroy Mr Cruz's reputation before that investigation had taken place, even though they felt it was in their interest to say the GFSC was trying to protect its reputation in the face of international press criticism. The court also heard detailed technical arguments on the issue of immunity and qualified privilege, matters which Mr Santos argued did not apply and were bedevilled with complexity and should not be decided on without the full facts at trial. He argued that the FSC had thrown everything and the kitchen sink at Mr Cruz, and after 2 years of delay, he should be allowed to have his day in court. The defendants aim to strike out the references to malice and bad faith at this early stage, which would then enable them to try and claim qualified privilege or immunity, which would allow them to apply for a summary dismissal of the claim. Desmond Brown QC, also of 5 RB Chambers, closed the hearing by referring to what he called the airy generalities of the case against his clients. He maintained that Mr Justice Yeats had made a fundamental error in his ruling on malice and bad faith and said this is not sustainable in law and should be struck out in its entirety.